Thank you. You may be seated. Good afternoon, everyone. Mr. Howe, if you would please call the case.
Yes, Your Honor. May it please the court, I'd like to call State versus Shawn Kemp. It's cause number 23-1011289. It comes on today for sentencing. My recollection is this court took Mr. Kemp's plea to one count assault 2, May 27th of this year. My name is Thomas Howe. I'm Pierce County Deputy Prosecutor. I appear today on behalf of the state. My colleague, who I'll sit down here in a second, so he can make his appearance, will be making the state's argument unless you have specific questions for me, Your Honor.
Thank you. Counsel?
Go ahead, Shawn.
Thank you, Your Honor. Good afternoon. Sean Plunkett for the state.
Good afternoon.
Good afternoon, Your Honor. Tim Leary on behalf of my client, Shawn Kemp, along with co-counsel Aaron Kiviat.
Hey, good afternoon. Good afternoon, Mr. Kemp.
Good afternoon, Your Honor.
This matter is on for sentencing. Are the parties ready to proceed?
State's ready.
Yes, Your Honor.
Okay. I'll hear the state's recommendation first.
Thank you, Your Honor. If it may please the court, the state did prepare and did provide a copy to the court prior to today's hearing, a PowerPoint presentation to kind of structure and present the state's argument, and also some of the exhibits that would be important for Your Honor to consider in determining this sentence. It was agreed in the plea that the parties could present exhibits or investigative material in its argument, so with leave of the court, I'll present that on the screen in the court here.
You may.
And kind of the structure of this PowerPoint is just to present some of the video evidence and photographic evidence. The first slide just details the crime, the level of the offense, and the standard range. The defendant comes in with 0 countable criminal history. His standard range is 3 to 9 months and up to 12 months of community custody, subject to Department of Corrections determination as to the appropriate amount, if any. Concerning this incident, in my PowerPoint and the exhibits, and I guess before I do this, I should move to admit exhibits 1 through 21 for the purposes of sentencing.
Any objection?
No, Your Honor.
1 through 21 are admitted.
Thank you. So the goal of the presentation, the exhibits, are to show what happened on March 8th, 2023, about 2 p.m. in the Tacoma Mall parking lot. It happened in the area between the J.C. Penney's and the Firestone business. My red pointer isn't showing up on the TV here, but the Firestone business is to the right of Exhibit 3. That's a screenshot.
I'm familiar with the area.
Thank you. The first of several videos the state is presenting is a compilation video. This was created by a retained expert by the state early in the case proceedings. It provides some information as to the date and time and highlights some of the activity. I'll play that now. This is Exhibit 1. There is no, there's no audio for most of this video and some audio towards the end. It would be okay with the court and the parties if I kind of skim through this to get to the most relevant portions. Thank you.
Fine by me. Any objection?
No, Your Honor.
Thank you.
Hey, Sean. Just tell them what this.
Yeah.
You want to narrate as well?
Thank you. I appreciate it. And after speaking with Mr. Lear, I will be narrating a portion of this just to give some context to what we're seeing. Earlier, we saw an SUV enter frame. That was the forerunner driven by the victims in this case. This is at the Emerald Queen Casino, as indicated at the title page. There was a white pickup truck that entered the frame earlier that had a little highlight. Investigation showed that that was Mr. Kemp's vehicle, his truck. And we briefly saw the Forerunner driven by Mr. Jackson kind of pass by the white Ford pickup truck, or excuse me, I don't know if it's a Ford, a white pickup truck driven by Mr. Kemp that night. And we saw the Forerunner exit the frame just a moment ago. And we appear to see that same Forerunner pass through the front of the frame in the parking lot of that casino in Fife, Washington. I'm going to jump ahead a bit here as we see the white pickup truck driven by Mr. Kemp appear to exit the parking lot. The next portion of this compilation video is one of the surveillance videos from the Tacoma Mall parking lot. We just saw the same Forerunner enter the frame and highlighted on the video there. We just observed the Forerunner park in a parking spot. Just entered into frame is a Porsche four-door that was Mr. Kemp's vehicle that he drove to the parking lot. And we're now observing Mr. Kemp exit his vehicle, appears to have something in his hands that he has placed on the roof of his vehicle. There will be a title screen indicating that there was 33 seconds missing from that video as the investigation received it. So there is the gap in this video. The male we're seeing out of the Forerunner attempting to close the driver's side door has been identified as Mr. DeJuan Jackson. That concludes the compilation video, Your Honor. Part of the compilation video was consisted of surveillance video from the Tacoma Mall and the JCPenney, including what I've submitted as Exhibit 3. What I'd like to do at this time is actually play a portion of Exhibit 3 from the exact file, because the Exhibit 3 file has a different player, and it allows you to zoom in directly on the file to get a better look at what's happening. If I can have just a moment. No, it should still be plugged in. Here's the monitor that's turned off here. Yeah, I think so. Let me just double check it. Yeah, still plugged into the HDMI. The only thing I unplugged was the audio. So I'm sure. I think he said HDMI 2.
That one's fine for this. I'll worry about the other TV to get that.
Okay. It's not up here. Okay, there we go.
We're good.
Okay, so we now have Exhibit 3 being published on the monitors in the courtroom. And as we can see, this exhibit, you can zoom in and move around the actual frame. So I just want to play the portion in which Mr. Kemp exits his vehicle upon arrival. So now playing Exhibit 3, and I'm focusing in on Mr. Kemp's Porsche. And the reason I'm focused on this, Your Honor, is the video shows Mr. Kemp exiting his vehicle with a bag of some sort and then removing what appears to be a smaller bag from that prior to him approaching the 4Runner. And from the video, it's pretty obvious that he's manipulating the bag, likely removing something. The state believes that that was the firearm, the revolver. And I'm just going to jump ahead a bit here. This is about the time where we have the gap before what we believe shows him firing the first shot. We just saw his right arm extended towards the 4Runner, and then his right arm extended again, more of a downward angle, but towards the 4Runner. And just skipping a bit ahead again, we'll see him approach the front of the 4Runner and appear to fire a third shot at this time. I'll now stop publishing Exhibit 3 and back to the PowerPoint. The next is a short cell phone video showing, this appears to be from the angle of a witness at the Firestone. A short cell phone video showing the 4Runner and Mr. Jackson flee. And I want to just ask the court to pay particular attention to the rear passenger window of the 4Runner and how it appears visually. We saw the 4Runner leave the scene out of the parking lot. I think this video will also show Mr. Kemp get back in his Porsche and then make that drive. As we saw in the earlier video, to the Firestone business, circle through the parking lot, and then appear to throw something into the bushes. And I'll retract that. This particular video doesn't show the drive to the bushes. The next slide has Exhibit 5 and also a portion of Exhibit 1, a screenshot. And in the compilation video, we saw what appears to be an adult male, white male, run into the scene. That's been identified as Mr. Boyagine. He's shown in the screenshot there on this slide speaking with Mr. Kemp. He was one of the first 911 callers. And by all accounts, the first person to speak to Mr. Kemp after shots were fired. And here we will hear some of Mr. Kemp's first statements about what occurred. And I'll play Exhibit 5. This is actually a portion of Exhibit 5 kind of truncated for purposes of the PowerPoint.
Everyone ready reporting?
Hi, students, Tacoma Mall, JCPenney Firestone.
Okay, has anybody been shot?
I don't know, I'm outside right now. I'm a security guard at Best Buy. Looks like gentleman, black gentleman, red vest, red car.
No, I work. Sedan truck SUV? Is it a sedan truck SUV?
Looks like a red car.
Okay, two-door, four-door?
I'm sorry, I got police on scene. Looks like a gray Toyota 4Runner running. Gray Toyota 4Runner
Down the
running.
units, okay. Can you see any part of the plate of the 4Runner?
I can't, they're gone.
Okay. Is that red sedan still there?
There's a gentleman, red. Looks like, hold on, I'm getting you the vehicle that was here. Looks like a black Porsche, AXL 5091.
AXL 5091?
Yeah.
Is that the license plate to the red sedan?
I'm sorry, AYL 5091, black Porsche.
Are they involved?
Yes.
Okay. Black Porsche sedan truck SUV?
Looks like a vehicle.
Okay. And did you see this vehicle firing shots?
Yes, it's on video at the Firestone.
Okay. Is that vehicle still there?
Yes.
Okay. Did you actually see the shots being fired from the vehicle?
I did not, I'm sorry.
No, that's okay. How many shots total did you hear?
About 4 or 5.
Okay. No one injured that you see?
You okay? You okay? Yeah, you're okay. Good.
Okay.
I'm with the mail here. I'm on the phone now, so just hang in there. They took all my shit on my fucking vehicle. Just keep your hands out of your pocket. Okay, you're fine. All right, thank
Are you injured in any way?
Are you injured in any way? No, man. Well, did you return fire search? No, I tried to say something to him, and then we got to shoot shit, man. Okay, don't worry about it. This is what happened. I didn't say
Okay, sir, may I have your last name?
Voyaging, Bravo, Oscar, Yankee, Alpha, Juliet, Echo, Alpha, November.
And first name? And your first name, sir?
Sheldon, Shelbon.
That concludes Exhibit 5. And, Your Honor, there were multiple 911 callers for essentially, the only thing they could understood was that there was shots fired at the Tacoma Mall. Mr. Boyagine was one of them. Mr. Kemp was not one of the 911 callers. There's no indication that he called law enforcement or called 911 at any point during this sequence of events. And one of the first statements we hear from Mr.
Can I stop you?
Yes.
Did I hear Mr. Boyagine say he was on the phone with the police?
I don't recall, Your Honor. Would you like me to play that portion again?
It sounded like he was trying to get Mr. Kemp to quiet down, saying, I'm on the phone with 911 right now. Did I mishear that? Do you want to play it back?
That sounds right, Your Honor, but I'll play that
That's just
portion
what-
again.
That was my perception, but if I'm wrong, I'm wrong, so,
I think he does say I'm on the phone with 911 right now.
yeah.
911 ready reporting. 911 ready reporting.
Students, Tacoma Mall, J.C. Penney Firestone.
Okay, has it, and did you see this vehicle firing shot? The vehicle still there?
I did not, I'm sorry.
No, that's okay. How many shots total did you hear?
About 4 or 5.
Okay. No one injured that you see?
You okay? You okay? Yeah, you're okay. Good.
Okay.
I'm with the mail here. It's the phone my shit. I'm on the phone 911, so just hang in there. It's all my shit on my fucking vehicle. Just keep your hands out of your pocket. All right, okay.
Okay, is he injured in any way?
That's all I needed to hear. Thank you, Counsel.
So the next few slides just have screenshots from that surveillance video that show what the state, believes are kind of important parts of this sequence. I won't detail each one of these here today, but it's contained on the state's exhibit, the PowerPoint. But we do have what we believe is the first shot being fired. That's when Mr. Kemp shows his arm extended towards the forerunner. Shortly after that, his arm is extended again, more of a downward angle. That's shown in the second screenshot on this slide. Then there is a slide to the left, or sorry, the photograph in this slide to the left there shows when he would have fired the third shot into the front of the forerunner. And then the last photograph is that fourth shot to the passenger side of the forerunner that was also captured on surveillance video that was shown in the compilation video earlier. There was a 30-second gap in that video that we had. However, the investigation, the police did obtain CCTV video from either JCPenney or the mall that does not have a gap. It is very grainy, but it's pretty clear where you can see where people are and what's happening. I'm going to play a portion of that to show that this video shows that Mr. Kemp, from exiting his vehicle to firing shots, at no point returns to his vehicle in between that time. So obviously very blurry, but I think we can make out the forerunner that's parked. We see a red car, passenger car here, a silver passenger car, and then the forerunner parked here. Kind of jump ahead until we see Mr. Kemp arrive. Excuse me. So this is Exhibit 6, now playing that from the PowerPoint presentation. So at this point here, we see Mr. Kemp's Porsche arrive and park, consistent with the earlier video. And we can tell this is Mr. Kemp, obviously, from the position in which this person has, associated with the vehicle. Also, although blurry, we can see his red attire, his red vest that he was wearing that day. To this point, we see the 4Runner begin to attempt to back out of the parking lot, consistent with the earlier video that was a reaction to being fired upon by Mr. Kemp. And at no time prior to this did we see Mr. Kemp return to his vehicle. And consistent with the earlier video, it's only after firing that third shot into the front of the 4Runner does Mr. Kemp return to his Porsche vehicle, which we can tell is occurring right now. With that, I will end publishing Exhibit 6. Proceed to the next slide. These are photographs of the 4Runner taken by Detective Quilio after the 4Runner was impounded and brought to a secure location. They're obviously, these photographs here, Exhibits 8 and 9, I presented to show the state of the rear passenger side window of the 4Runner, and State did present Exhibit 20, which is a portion of Detective Quilio's police report in which he describes that the rear passenger side window of this 4Runner was actually an acrylic type pane that was inserted into the window frame and was inoperable. In other words, it doesn't roll down, it doesn't roll up. Here we see 2 trajectory rods into 2 defects bullet holes. This is Exhibit 10. One is to the kind of front quarter panel, if that's what it's called, and also the front passenger side door. These appear to be consistent with the first shot and also the fourth shot that we saw in the earlier videos.
Okay, counsel, I'm kind of confused. You've said you've given 2 recitations, 1 3 shots from his firearm, and now 4 shots from his firearm.
There are 3 shots that impacted the 4Runner. A 4th shot, which appears to be the second shot in sequence, entered a Subaru Impreza. So these are 2 shots to the passenger side of the 4Runner, shown here Exhibit 11 with their evidence markers, forensic markers, and then a shot to the front of the 4Runner in the license plate area, shown here in Exhibit 12 and 13 with the trajectory rod. There was that Subaru Impreza, a silver passenger vehicle that was in front of Mr. Kemp, as Mr. Kemp was kind of in between a red passenger vehicle and a silver passenger vehicle. This turned out to be a Subaru Impreza owned by, I think, an employee of the mall who had it parked there during the day. This had a bullet defect consistent with where Mr. Kemp was firing from. The bullet was removed from kind of this door window top panel by Detective Quilio, maybe with some assistance from the body shop employee. The bullet was removed, and I think this is consistent with what we saw in the surveillance video as kind of the second shot where Mr. Kemp's arm is extended but at a more downward angle in front of him. This is the firearm that Mr. Kemp used. This was recovered, photographs taken. It's a .357 Magnum revolver. It's a 6-shot cylinder. And again, 4 rounds fired that we can account for. 3 that went into the 4Runner, 1 that went into that Subaru, just uninvolved, parked, unoccupied. Seemingly unintentional by Mr. Kemp to fire into the Subaru. 1 live round was left in the cylinder. 5 shell casings were left in the cylinder. We can't account for why there were 5 shell casings, and although we can account for 4 bullets, there were 5 shell casings in the cylinder, indicating that at some point another one had been fired, maybe unrelated to this incident. There was also a live round found in between the vehicles, that being the Subaru Impreza, the silver passenger vehicle, and the red passenger vehicle. I believe it was a Ford Focus, where Mr. Kemp was during the shooting, so perhaps he may have dropped it when this was going on. Also, there was a Crown Royale bag found in Mr. Kemp's pocket during a search incident to arrest. By appearances, very consistent with what we saw him handling as he exited his Porsche vehicle. Inside the Crown Royale bag were 5 more live rounds of .357 Magnum inside that bag, inside Mr. Kemp's pocket. There were also additional 2 live rounds found in the center console of Mr. Kemp's Porsche during a later search. You know, we've presented this information because one of the primary issues at sentencing is whether or not there's some indication, there's some evidence that Mr. Kemp acted in self-defense. He has, of course, pled guilty, but in an argument, defense's argument for an exceptional downward will be based out of whether or not the court believes that there's sufficient evidence that Mr. Kemp, or excuse me, Mr. Dwan Jackson, or Mr. Joshua Puente. Joshua Puente was the male identified as seated in the back seat of the 4Runner. The issue is whether or not there's sufficient evidence for Your Honor to find by preponderance that Mr. Kemp was fired upon first.
That's not the standard. If that were the standard, he would be not guilty of the charge. In all the case law, okay, all the case law reflects that a person can pursue an exceptional downward based on a failed defense, meaning that if the defense actually existed, they would never be convicted in the first place. And there can be a whole host of reasons: misperception by the defendant, the initiator was the victim, or the aggressor was the victim. Okay, but that's the standard. When I read through the state's arguments, the biggest problem, and I'm going to ask you to address this, is the tone that I got from your argument was there was no self-defense because there's no evidence that this occurred. Okay, even if I take that at face value, okay, there can still be a failed defense. Okay, now it is true that Mr. Kemp has to present both factually and legally that he's entitled to that exceptional downward. Okay, so there has to be some evidence, okay, that he acted in self-defense. For me to make that factual finding, there has to be some evidence. But it's never been stated that it has to be by a preponderance. Okay, and we know it's not beyond a reasonable doubt either. So how do you square that with your argument? And I'll give you a couple of examples. One, the person closest to the vehicle was Mr. Kemp himself. He told police that he was fired on. Correct?
Correct.
That's evidence of self-defense, is it not?
Yes.
Okay? All right. Later, the vehicle itself is found, and in the vehicle is a holster, and the holster is found lodged in the dashboard. Correct?
That sounds right, yes.
Yeah,
Center
and
console dashboard
the
area.
front panel, in other words. The way it was described to me, it was lodged in the front panel. Why would you put a holster in the front panel?
I can't speculate to that, Your Honor. I mean,
I'm sure you can make an
for it to be
educated guess.
accessible, I mean, that would be me
Yes, so a
guessing.
firearm is easily accessible
Right.
while you're in the vehicle? Wouldn't that seem to be an educated guess?
Yes.
Can I rely on circumstantial evidence to find that the defendant has met his factual prong for an exceptional downward? Or does it have to be direct evidence?
No, direct and circumstantial evidence is equally reliable if, subject to your own interpretation of, the power of the evidence.
Agreed. Agreed.
So what I refer to as by a preponderance of the evidence comes from the departure from guideline statute. And I mention that because it says that, if the court finds that mitigating circumstances are established by a preponderance of the evidence. So that's why I refer to that standard at this point in sentencing. So in order for Your Honor to order a departure downward, in our briefing we did cite case law that the defendant has the burden of proof to prove the mitigating circumstances, and is by a preponderance of the evidence. Certainly there can be other circumstances, But I believe that the defense's argument for self-defense is grounded in the fact that he, from the very beginning, stated that he was fired upon first.
Now, I'm not disputing that. I think you're correct in that respect, okay?
The surveillance video, the photographs taken of the Forerunner are inconsistent with Mr. Kemp's statements to police and detectives. His first statements to Mr. Boyagine were that he did not fire. Mr. Kemp admitted to police that he did fire at one point during the initial investigation. It's contained in State's Exhibit. This is Officer Schneider's body-worn camera. He's one of the first police officers on scene to make contact with Mr. Kemp. One of the first things Officer Schneider asked Mr. Kemp is, where's the gun, or do you have a gun? Something to that effect. Mr. Kemp says that he doesn't have a gun. Something to that effect. Mr. Kemp provides his statement of what happened to Officer Schneider. At some point, Officer Schneider gets information from a fellow officer that witnesses had observed what they believed as Mr. Kemp firing at the people in the Forerunner. It's at this point that Officer Schneider places Mr. Kemp in handcuffs to be detained and then asks Mr. Kemp, did you fire? At which point Mr. Kemp does admit that he did fire. Later, throughout this investigation, Officer Schneider asks him, where's the gun at? Or he asks, where's the gun? Mr. Kemp doesn't advise law enforcement that he had threw the firearm into the bushes at the Firestone. It's only after police retrieve the revolver out of the bushes from the Firestone, because witnesses had directed police to that location to go find it. They then bring the gun back to where Mr. Kemp is with Officer Komorowski, Officer Schneider. The status of the gun is that it's cocked, it's fully cocked with a live round in the cylinder, so much so that police have to be really careful on how they render the gun safe. Only when the gun is then with law enforcement in front of Mr. Kemp and they ask, is that the gun you used, does Mr. Kemp admit that, yes, that's the gun I used. Prior to that, he doesn't direct law enforcement to go get the gun out of the bushes. So the state's argument, Your Honor, is that Mr. Kemp's statements that would support a self-defense finding for purposes of sentencing and exceptional downward is contradicted by the surveillance video, the fact that the Forerunner rear passenger window that Mr. Kemp had, throughout his statements, had said that had rolled down and then a shot had been fired at him was inoperable. He had stated to law enforcement and detectives that he walked up to the Forerunner, was fired at, and then he went back to his Porsche to retrieve a firearm to then fire back at the occupants in the Forerunner. The surveillance video shows that at no point until after he had fired at least the third shot into the front of the Forerunner did Mr. Kemp go back to his Porsche. We believe that the evidence shows that he, as soon as he got there, he got his firearm out of his vehicle, he approached the persons in the Forerunner, fired shots at the persons in the Forerunner, and we believe the evidence contradicts any claim of self-defense. So it's the state's recommendation to sentence within the standard range. Based on several factors that I've outlined in my briefing, we believe a high end of the standard range is appropriate, up to 12 months of community custody, subject to Department of Corrections kind of evaluation and what they believe is appropriate. And all other standard fees. DNA will need to be collected, obviously. We're also asking for a 10-year protection order for the two victims, Mr. Puente, Mr. Jackson, and then restitution left open for 180 days. If I may have just a moment to confer with my co-counsel. Your Honor, that concludes the state's recommendation and presentation of evidence. Does Your Honor have any other questions?
I do. What do you make of the claim that Jackson, some weeks after this occurred, shot at a person in a rent and service station, hit him 3 times, and believed that person to be Shawn Kemp?
Is the court comfortable with me answering that?
That's fine. You can answer.
At that point, apparently, Mr. Jackson knew that the person that was involved in the incident at the Tacoma Mall was Mr. Kemp.
Right.
Mr. Jackson, in his defense interview, indicated that it was his belief that in retaliation for them doing the car prowl of his vehicle, that Mr. Kemp himself and through proxies was stalking him. I don't have any reason to believe that that's true, but that's the belief that Mr. Jackson expressed during the defense interview.
And I believe you brought that to my attention during the pretrial motions.
Okay. yeah.
You talked about that during the pretrial
But
motions.
as far as this proceeding goes, assuming that, as I understand it, that the defense's argument for a downward departure is based on failed self-defense, it's completely irrelevant. Mr. Kemp did not know at the time that he fired those shots that that was going to happen 6 weeks later. It has zero relevance to this proceeding.
Okay. Agreed. Can the court consider that as circumstantial evidence of the intent of Mr. Jackson, even though the shooting took place some weeks after this shooting?
No. So we have a evidence rule 404B, right?
Right.
That says, and the reason, not more than the text of the rule, the reason that rule exists is because no court should make a determination based on what's called propensity evidence. That's what this would be.
That's what you argued pretrial.
I
And
think I was
that
right. I didn't remember that, but yeah.
I'm certain you think you were right, Mr. Howe. That's not my point here. My
Okay.
point here is, this is sentencing, okay? So the court has much more freedom to consider all types of evidence. Could not the court consider that Mr. Jackson shot someone he thought was Mr. Kemp some weeks after this particular incident to understand as circumstantial evidence of what Mr. Jackson's intent was on that date?
No, because when this incident took place, the one in the Tacoma Mall, the one that led to the charge, Jackson didn't know it was Shawn Kemp. He had no knowledge that it was Shawn Kemp.
Didn't the night before at the Emerald Queen, they came face to face, right?
They came face to face, right? But
And
it's
that-
not my understanding that Mr. Kemp identified himself.
Okay, hold on, let me finish my question.
Sorry.
And then Jackson and Puente throw out items,
Right.
one of which is a check belonging to Mr. Kemp?
There was a check. I don't know if that had Mr. Kemp's name on it or not.
Well,
There was a check.
that's what I'm asking. That was in your pretrial motion. That was in your trial brief, in your pretrial motions, that and I can't remember the woman's name, found these things, got a hold of Mr. Kemp, and that's how Mr. Kemp ends up back down in the Tacoma area, right? Correct?
Absolutely.
Okay.
Well, no, actually, the way he ends up down in the Tacoma area is by tracking the cell phone, stalking Mr. Jackson and Mr. Puente. She doesn't live by the mall.
Okay.
After he got that stuff back, at that point, he used his other cell phone to track them to the Tacoma Mall.
I recall. Yeah.
Okay, so there was a check in the things that were discarded, absolutely. So I guess it's conceivably possible that at that point, Mr. Kemp's name comes up.
Okay.
But the point really here, I think, is that at the point in time that Jackson does the assault 1 or 2 or whatever it was that he gets convicted for, he gives that explanation of why he did it, I think in a pre-sentencing report, if I'm not mistaken. If you go back to the video of this incident, okay, one of the really important points, and I know this court has looked at a lot of videos of shootings, and so have I. And the thing that is the most interesting about everything that you saw here today is at no point does he flinch. At no point does he look like he's trying to protect himself. He turns his back on that vehicle, and that's impossible under circumstances where he just got shot at. To go back to the preponderance thing, if I could, I think the point is that the court has to base this on facts that the court believes is true.
Correct.
And if you believe a fact is true, I think you have to believe that particular fact to preponderance of the evidence, if that makes sense. You have to be you have to be convinced that that fact is more likely true than not. And if you base your decision on self-defense, which they say is based on the fact that he shot first, that Jackson shot first, I think you have to be convinced that it's more likely than not true that Jackson shot first. That's the argument that they're making. They're the ones that know what's inside his head. And I suggest to the court that, like I said, I know you've looked at least as many videos of shooting as I have. There's no way that the man that fired those shots was shot at first from that video. Do you have other questions for me?
I do not. Okay, we're going to take a short recess. I want to remind people in the gallery, you may not record these proceedings, okay? Put your phones away. Understood? Thank you. We'll be at recess.
All rise.
considered and what's not. I think the court and the state and the defense are aware of what factors go into whether or not to impose an exceptional sentence down, but then there's also the analysis of where to fall within the range. And I think there is a plethora of issues and topics that will be discussed that will go to whether or not we're in the range, but then also I'm going to focus my conversation or my argument with respect to the exceptional sentence down. As the court noted, all of the cases cited were post-jury verdict cases where the jury explicitly rejected beyond a reasonable doubt the defense's argument as to self-defense. And the court found that and upheld exceptional sentences down. So the issue here is my client reported, Mr. Kemp reported being shot at, being in fear, and that was what his response was. There's not a proportionality test. There's not concluding beyond a reasonable doubt. It's, as the court noted, a failed, whether or not, even if it's not sufficient to convince a jury, the court, the legislature has entrusted the court with the ability to do a safety valve and to impose an exceptional sentence down. So there are three people who know what happened. My client, Mr. Puente, Mr. Jackson. Two of them are in prison. My client is here. My client reported being shot at. The video we have, there's a 33-second blank spot where my client reported during that period of time he was shot at. What I think is significant about that fact is this is what he said on the scene. It wasn't a situation where after viewing the video he then says, well, it was in this black spot that's when all this bad stuff happened. That's what he reported. He had no idea whether there was video or not. The state's argument rejecting an exceptional sentence talks about the actions of my client afterward. Not what he did in the moment, but what he did with the gun, the depth and the accuracy in what he perceived and what he reported afterward. The question is based on what happened in the mall when he fired, given the totality of the circumstances, is there a basis to impose an exceptional sentence down? And I believe that there is. I think the facts support it, the law supports it. Ultimately, that decision rests with Your Honor. I do want to address some of the factual pieces of significance in the state's presentation. What struck me as I watched again was the cell phone video from the Firestone that captured the face of Mr. Jackson as he's driving away. He's leaning out of the front seat of the car, and he appears to be angry and yelling at my client. That demeanor is significant. You know, that's how he's responding to Mr. Kemp. He isn't, to say that he didn't know who Mr. Kemp was, I think rings hollow. You saw him drive, that stolen 4Runner at the Emerald Queen Casino, drive directly to that truck in an isolated part of the parking lot, the truck they had broken into hours before, do a slow pass by, and look at my client. It's not clear whether they're talking, whether the windows are down, has a clear view of my client. We also know that there was a large amount of memorabilia stolen from my client's car, along with the check. And to answer the court's question, the Good Samaritan who found the check and some of the belongings was in Pierce County. So he was already down in Pierce County. He then looks at the phone and says, that's where they are. When he goes, he says that the shot was from the car. He thought it was from the back window. Notably, the front window is open. And so whether or not the shot came from the back window or the front window, the bottom line is the front window is open. And, to say that the shot didn't happen because there's still plexiglass in the back window is not dispositive. So the court has this discretion as to whether or not, and looking at how this circumstance came to be, who was the initiator, the aggressor, and the provoker. Now, the question is do you look at the moments, the 33 seconds that the video is dark, and the actual shooting itself, or do you expand to look at what happened at the Showbox Theater, what happened at the Emerald Queen Casino, and then what happened at the Tacoma Mall? I think there is significant issues with Mr. Jackson and Mr. Puente. yes, I would agree that my client wasn't aware of Mr. Jackson's history, but at the same time, he's able to detect his demeanor and what he is capable of. He obviously had no idea what he was going to do 2 months later at the Fred Meyer when he walked up unprovoked and shot somebody. My client had reason to fear, and he acted the way he did. What the court is now going to hear from is my client and other individuals that I anticipate that Mr. Kemp is going to get up here and share with the court what he has told me from the beginning, which is, I screwed up. This is not what I should have done. I'm embarrassed. I'm better than this. I'm 55 years old, and I wish I'd done better. This was a bad situation. He told me from the beginning he wishes that he called the police. It's property. And he understood 2 years ago, and he understands today what could have happened. He pled guilty to take responsibility for what he did. And the question here is not whether he's guilty, not whether he's forever going to be a convicted felon. The sole question that the parties are in disagreement about is what is the appropriate sentence. And as I said in the brief, consequences and sentences take many forms. The most obvious one we always think about is in terms of custody. You're going to hear from speakers, there's about 5, and we're going to keep it short, but the amount of work that my client does with the community and kids, and his embarrassment talking to kids, but that he isn't shying away from that and telling them, I didn't choose well, do better. One of the hardest parts in this past 2 years is oftentimes you will see celebrities and politicians who have the cameras follow them around and detail all the good works that they do to put it on Twitter, to put it on social media. Shawn doesn't like any of that. There was part of him that asked that he didn't want anyone to speak on his behalf, didn't want his family present, because he's embarrassed. He doesn't want to bring other people in when he knows what he's responsible for. So I'm going to turn it over to my colleague, Mr. Kvyat, who's going to introduce some speakers with the court's permission, and then finish with Mr. Kemp.
Thank you.
Thank you, Your Honor. So our intention is to call for people to speak on Mr. Kemp's report. I would like to just acknowledge some of the people who came to show Mr. Kemp's support today who won't be talking, and those include Louis Rudd, Dr. Angela Griffin, who's the CEO of Bird Bar Place, Mr. Nate Miles, who's with the National NAACP Foundation Board, Shelley Seacrest, who's the president of Alaska, Oregon, and the Washington NAACP, Dominic Davis, who's the CEO of Community Passageways, Pastor Tony Montgomery with Father's House Church, and Marshawn Lynch. Thank him for being here. We'd also just like to thank and have you on a note that he has a lot of family and friends here who support us and are here to support the defense recommendations.
Okay.
So
I want to mention, before you call your first individual, I did review after receiving a number of letters from supporters of Mr. Kemp. In addition, I also read the victim's statement, which was filed in links as well. I think I covered everybody that sent something either to the court or filed it in links, so everyone understands that I did review all of that. Okay.
Thank you, Your Honor.
we appreciate your time.
Go ahead and call your first.
So, Your Honor, the first person we'd like to call is Reverend Dr. Paul Stoop. He is the executive director of the Rise Up Academy. And Your Honor, where would you like?
So what I'd like is kind of over by you. Let's move that chair out of the way.
This chair?
Yeah.
Okay.
Sir, if you come forward over here by defense table, right over there. Right over by counsel there. And if you would start just by stating your full name and spelling your name for the record.
Dr. Paul A. Stoops, Senior, S-T-O-O-T.
Okay, thank you. Go ahead, sir.
Thank you, Your Honor, for allowing me to speak on behalf and stand here before you and the courts. I must say that I'm not here to check the box, simply to seek leniency and say that this is what Shawn has done in the last few weeks, few months. No, but to implore you to consider the profound impact that he has had and he continues to have on our community. Shawn Kemp is not just a former Sonics player, but a devoted husband, father, grandfather, a passionate advocate. And from my dear friend who I spoke with last night, Nate Miller, she said that he is a man that is about the children. Shawn has been a beacon of hope for those in darkness. And I saw that when he comes, and as he comes to speak to some of the children that I've been serving for the past 26, 27 years. He tirelessly served communities from Pierce County to Snohomish County and beyond, even College County. Shawn is a man of faith whom I've known for over 25, really nearly 30 years, pastoring the church I served at. I met him through Nate McMillan, former NBA player, Sonics coach, and current coach for the Lakers, who played alongside with Shawn. Nate said some words to me last night. He said recently what expressed him to feel so compassionate about Shawn that he remembers is how he has such admiration and he has such a positive impact and influence on the lives of those that he touched on the court as well as off the court. Shawn has shown remarkable leadership within our church, working with men for the past 20 plus years. Running to Shawn, he's always saying, can I come talk to your men? Can I come talk to your men? I want to share light and inspiration of the men. He's dedicated himself to uplifting those who cannot speak for themselves, offering his time, his energy to inspire and guide, especially our younger generation. I've witnessed him firsthand some weeks ago. I don't know how he did it, or what caused him to do it, but as he was talking to one of the kids, he was signing the autograph and crying at the same time. Tears just began to fall, and he's sharing with the children openly and saying to them his mistakes that he's made, urging them to learn from his experience and to strive to do better. I close by saying this, that throughout my conversations with Shawn, he's had such an earnest impact, not just on the lives of those that he's speaking to, but on the lives of those who's listening to him. Me being who I am and where I've been, from the United States Navy to engineering for Boeing, to pastoring the church for over 32 years in Snohomish County. He's brought me to tears just to tell how he wants to make a difference. So, Your Honor, I respectfully ask that you would consider allowing Shawn to continue this invaluable work throughout the community of service in which he gives. And if it be granting him some more hours up this county line, that I can follow him, watch him, and I don't mind saying cry with him as to the heart of what he's saying to the families and to the children. I'm committed to stand alongside Shawn as a mentor, sharing accountability, the support that he needs, and to fulfill the things in which he's committed to in all of our communities. Thank you for considering this request, for allowing me to speak on behalf of not just Shawn Kemp, but Mr. Shawn Kemp, because we know, and in the work that we're in, there's always room for grace, and mercy always loves shaking hands. Recognizing that while we all make mistakes, it is our actions moving forward which really defines us. So I stand before you as a man of the cloth and say that these are not just mere words. I had a cardiologist appointment today because of a recent heart attack. This was more important to me because it not only touches my heart, I canceled that appointment to be here in Snohomish County. Because Shawn cares.
Thank you, Doc. Mr. Kibia.
Thank you, Your Honor. We Next, I'd like to ask you on the permission to hear from Marvina Kemp, Shawn's wife.
Certainly. Good afternoon. Can you please state your full name and spell your name for the record?
My name's Marvina Kemp, M-A-R-V-E-N-A.
Okay, you might have to speak up a little so everybody can hear you, okay?
My name's Marvina Kemp, M-A-R-V-E-N-A.
Okay. What do you want to tell me?
So I want to tell you that it's been tough for the last 2 years of dealing with this. Me and Shawn have been married for 24 years. He has supported my organization and the community for the last 25 years during Secret Santa, basketball camps, donating to community centers, high schools, and just giving a hand in need. He's very remorseful. It's been stressful. He apologized. It's been tough, and hopefully you take this in consideration.
Thank you.
Thank you.
Your Honor, next, we'd like to ask for permission to call Paula Sardinas, who's the CEO of Washington Build Back Black Alliance.
Good afternoon, Your Honor.
Hi,
Paula
good.
Sardinas, S-A-R-D-I-N-A-S. I am the president, CEO, and the founder of the Washington Build Back Black Alliance. We represent 100 community-based organizations. Those are youth organizations. We are certified in victims advocacy. I am here today as Shawn Kemp's friend of more than a decade. Shawn is extraordinary. Your Honor, in the 10 years that I've known Shawn, I've never known him as a famous athlete. I've never known him as a supersonic. I've known him as a superhuman. Shawn has given quietly, consistently, and selfishly, never asking for recognition, compensation, or accolades. His heart has always been with our youth, especially those who are often forgotten. I've seen Shawn provide backpacks filled with school supplies and essentials to children who don't know where their next meal is coming from, let alone where they're going to get things for school. I've watched him invest in youth camps and making sure that our youth who have mental health issues know that they are seen and that they are recognized. Time and time again, our young people reach out to him because they know Shawn's going to listen. He's going to listen without judgment. He's going to remind them that they matter and that they are worth fighting for. Over the years that I've personally worked with him, I've heard testimony from parents, from children, but from educators that without Shawn, they don't know how they would have made it. Whether it's mentoring young men behind prison walls or speaking with kids in detention, he volunteers his time to uplift those kids who feel invisible. Shawn has shown through his actions that he will never give up on people that society has written off. I live in the community where Echo Glen resides. I hear from those children time and time again that the walls are closing in. I have called Shawn Kemp at 6 o'clock in the morning and asked him to be somewhere at 8 o'clock, and he said, "Paula, send me the address and I'm there." Justice Ruth Bader Ginsburg once said, "Fight for the things you care about, but do it in a way that leads others to join you." This is the essence of who Shawn is. He's fought for our youth. He's done it with dignity. He's fought for their futures. In doing so, he has inspired me. Your Honor, I know that Shawn stands here today in a difficult position. He should not be defined by a moment in time. He should be defined by the countless lives that he's saved, the children that he's touched, the communities that he's strengthened, and the nearly 30 years that he has dedicated his life to the Puget Sound. I'm honored to call him my friend. I have had more than 25 schools here in Pierce County reach out to me and say, "Paula, can Shawn visit my school? Can he speak to our students?" On the 28th of this month, he will receive the Lenny Wilkins Profile and Courage Award that honors his lifetime of commitment. Your Honor, I know he made a mistake. I'm sorry to the families and I'm sorry for the people that have been impacted, but it doesn't define who he is. Thank you for allowing me to stand up for Shawn Travis Kemp, who is my friend.
Thank you.
Your Honor, I'd like to ask permission for William Scott Boatman, who is a close friend of the family and Mr. Kemp's attorney, personal attorney, to speak if we could, and then we'll hear from Shawn.
That's fine, thank you. Mr. Boatman, if you could move right up here, go ahead. State your full name and spell your name for the
My name
record.
is William Scott Boatman. I am, as Mr. Kiviat mentioned, I'm Shawn's attorney, close friend, business partner in a handful of ventures. And truly, over the last 30 years, we've become like brothers. And it's in that capacity, as someone who's known him over 30 years, which means I've known everything in his life, good, bad, and in between, that puts me here to talk about him and to share a few thoughts about who he is and how this incident has impacted him. But for me to talk about who Shawn is, I've got to talk about who he isn't. He isn't a criminal. He isn't a violent person. He isn't aggressive. He is not even an instigator. He wasn't as a ball player. He wasn't as a person who was constantly being provoked at bars or restaurants. He has no history of that whatsoever. Who he is, and I apologize for the redundancy, he's a son, he's a father, he's a husband of 25 years. He's got 4 grandchildren. He'll proudly tell you that all of his kids are college graduates. He is a family man, right? Years of growth for me to be able to say that here in court. And everyone is familiar with Shawn's community work. But as Marvina mentioned, it's been going on for years. Through her foundation, the Marvin Thomas Memorial Fund, now through his own work with the Rain Man Foundation. This is work that not a lot of people know about because he does it for the right reasons. He's not trying to monetize it or leverage it. He's not trying to build a brand. In fact, even a week ago, he was off doing something. I said, Shawn, that's important. We got sentencing next week. And he said, I'm not doing it for that. You know that. And I said, yeah, I know. So that's him. That's who he is. There's these smaller incidents that really define who he is, in my opinion. Things that you wouldn't hear about these things. He used to go to the Amazon employee event that was held at the Seahawks Stadium, and for 2 hours he'd be there. He'd be paid to be there. An hour on the court field with the court they set up. An hour in the owner's box with the executives. So 2 hours comes and goes, and the promoter calls me, and he's in a panic. He said, hey, what's going on? You got to get a hold of Shawn and tell him he's done. He can leave. I said, what's going on? And he said, well, he's already done everything. We don't have the budget to keep paying him. I said, well, what are you talking about? He's like, well, he's on the court again, shooting balls with all those kids. I said, he just told those kids he'd be back. Those are probably the kids he didn't get his chance to shoot the ball with before he went up to the suite. And so that's Shawn. He got a $10,000 fine when he was a player because he was late getting on the bus that was 20 feet away from him because he wasn't done signing autographs for the kids. That's Shawn, right? And I wish more people knew that about him, right? But he's got a small circle of trust. I'm lucky to be in it, right? And in 30 years, through all those ups and downs, I've never ever seen Shawn so impacted by anything like this has impacted him. He has a level of regret and remorse unparalleled, right? And he's not hiding from it. He'll own it. He's trying to learn from it, but to also help others with it, right? He, without anyone asking him to, within a week after he entered that guilty plea, he was out talking to kids about gun violence, about making smart choices. Even if you're scared, even if you're in a bad spot, you got to make the smart choice, right? He knew that was going to be his message, not because I'd be here saying that, or that he might say that, or that anyone else might say that. That was just the right message to share, because that's really who he is. I'm on a short leash. I'm not here in a legal capacity, but I am a lawyer, and I remember a few things from criminal law. Incarceration here, there's no rehabilitation, there's no public safety issues. It's punishment is the issue. And punishment, as Mr. Larry pointed out, can look differently, right? Mr. Kemp's been sued in a civil suit by one of the other individuals. This is not something that would just fall off him in a couple of years. Most people, when things like this happen, it's a bad couple of years, eventually people forget. This is a new chapter for him to live with the rest of his life, right? It's one more thing people are going to think of when they think of him, unfortunately. So he's trying to make that better. Punishment here has been served. I don't see any benefit from any other type of punishment happening here. I really do thank your time. I appreciate your staff's time. I really want to just tell you how grateful we are as a team, as a family, and not only for your time, but for your consideration. Thanks.
Thank you, Mr. Bowley.
And Your Honor, I've discussed Mr. Kemp's right to allocate as a citizen, and he does have some words that he'd like to share.
Mr. Kemp, before you start, sir, so you have the right to address the court prior to me imposing sentence. You're not required to, okay? And if you decide that you don't want to, I wouldn't hold that against you, okay? Just so you understand that. But now's your opportunity to tell me what you think I should know before I impose a sentence. You may.
Well, when I say this, when this incident happened 3 years ago, it's kind of changed every aspect of my life. Just from the standpoint of me being involved with so many kids. Just so much youth looking up to me. So the way that this has changed my life is that for the rest of my life, I have to be an advocate of gun violence. I have to go out here, talk to these kids, explain myself, my actions to these kids to try to save their lives. So the impact is real. And I think I appreciate everybody's kind words, but I accept the responsibility for what I did. I should have used a better discretion. I haven't got this successful in life without using those discretions, and I'm very apologetic for what I did. Thank you.
Thank you. Mr. Leary, Mr. Kvyat, anything else?
That is all that we have, Your Honor.
All right, thank you. Okay, as I indicated, there were a number of letters and submissions to the court throughout the last couple of weeks from supporters for Mr. Kemp as well as the victim, one of the victims in this particular case. I did have the opportunity to review them all, and I took them into account in making my decision here. Shawn Kemp is before this court for sentencing after pleading guilty to one count of assault in the second degree. Mr. Kemp was originally charged with one count of assault in the first degree, and that information was later amended to a second count of assault in the first degree and one count of drive-by shooting. Trial in this matter commenced on May 22, 2025, before this court. However, prior to opening statements, Mr. Kemp changed his plea after the parties negotiated a resolution and filed a second amended information. In the prosecutor's statement regarding the amended information, the prosecutor stated that there are, and these are the reasons why the state determined that they would move to amend the information, that there are 33 seconds of the encounter between Mr. Kemp and the two victims that did not record prior to the shooting by Mr. Kemp. The state lists as additional reasons that the two victims both have lengthy criminal histories that would not be helpful in demonstrating their credibility, and that they were illegally in possession of items stolen from Mr. Kemp that he was attempting to recover. Those facts, according to the state, left them with a dilemma of whether they would be able to secure a conviction as to the charges in the first amended information. Here, the state seeks a sentence of 9 months incarceration and argues that that is typical for similar types of cases. They also point to the fact that the shooting took place at Tacoma Mall, a crowded public place in which endangered many other people nearby. It is also argued that Mr. Kemp was inconsistent in his responses to the police about the shooting and the aftermath. Mr. Kemp comes before the court with an offender score of 0, having no criminal history to speak of, and his standard range is 3 to 9 months. Both parties agree on those facts. Defendant seeks an exceptional sentence downward to no additional time, and the sentence itself, by statute, carries with it a requirement of up to 12 months of community custody. RCW 9.94.1010 sets forth the purposes of sentencing in Washington for felony offenders, which structures but does not eliminate discretionary decisions affecting those sentences. First, to ensure the punishment for a criminal offense is proportionate to the seriousness of the offense and the offender's criminal history. Second is to promote respect for the law by providing punishment which is just. Third is to be commensurate with the punishment imposed on others committing similar offenses. Fourth is to protect the public. Fifth is to offer the defendant an opportunity to improve himself or herself. Six is to make frugal use of the state's and local government's resources. And finally, 7, to reduce the risk of reoffending by offenders in the community. Turning to the statutory authority for exceptional sentence downward, that is 9.94A.535. A court may impose an exceptional sentence below the standard range if it finds that mitigating circumstances are established by a preponderance of the evidence. The following are illustrative only and are not intended to be exclusive reasons for exceptional sentences. There are 2 that potentially may apply to this case. The first is subparagraph A. To a significant degree, the victim was an initiator, willing participant, aggressor, or provoker of the incident. And C, the defendant committed the crime under duress, coercion, threat, or compulsion insufficient to constitute a complete defense, but which significantly affected his or her conduct. Now, the state argues here that there is no evidence of any shots being fired at Mr. Kemp. Neither the video nor the eyewitnesses at Tacoma Mall provided any evidence of shots coming from the stolen vehicle that the victims were driving. Hence, the state argues there is no factual basis for a claim of a threat to Mr. Kemp that would allow him to employ self-defense. That assertion, however, is not entirely accurate. First, there is evidence that a shot was fired. Mr. Kemp himself, who was closest to the vehicle, stated he was shot at by one of the occupants, and therefore he believed he was justified in using potentially deadly force by firing at the vehicle. Circumstantial evidence also supports the claims of Mr. Kemp. First, recall that when the stolen vehicle was recovered, police found a holster wedged in the dashboard. No gun was found, nor shell casings in the vehicle. But placing that holster where it would allow the driver or the front passenger to quickly arm themselves in the event of a shootout is a plain explanation for that evidence. Indeed, the court cannot think of another reason to place a holster there. Moreover, there is the incident that occurred in a Renton gas station some weeks later, where Mr. Jackson donned a mask, armed himself with a handgun, and shot a gentleman who was filling his car with gas. The evidence exists that Mr. Jackson believed he was shooting at Mr. Kemp. This evidence, were it to be presented to a jury, in this court's opinion, is strong circumstantial evidence of Mr. Jackson's intent, and therefore the claims of Mr. Kemp. The court has reviewed, I believe, every case in which the court reviewed a mitigating sentence downward. The court finds several that are instructive, and I'll cite a couple for the parties. First is State versus Whitfield. In Whitfield, the defendant was charged with assault in the third degree and disorderly conduct. The charges arose from an incident in September 1998 where Whitfield assaulted his niece, Lynetta. Whitfield and his extended family had gathered for dinner. Most of the adults, including Lynetta, were drinking alcohol. Lynetta had fought with others before the incident with Whitfield. In Whitfield's presence, Lynetta repeatedly confronted Whitfield's fiancée about other women that Lynetta claimed Whitfield was seeing. After several unsuccessful attempts to extract themselves from the conversations, Whitfield and Morris decided to leave. They collected their belongings, child, and left the house. headed towards their car. Lynetta followed them outside and continued to confront Morris. Whitfield responded by assaulting Lynetta. He repeatedly hit her in the face and body, causing bruising on her entire face and her left eye to swell completely shut. The assault stopped only when a relative heard the commotion, came outside, and pulled Whitfield off Lynetta. Whitfield pleaded guilty as charged. He admitted that during the struggle with criminal negligence, he caused Lynetta bodily harm accompanied by substantial pain that extended for a sufficient period to cause her considerable suffering. The standard range for Mr. Whitfield was calculated at 22 to 29 months, and the state recommended a sentence of 22 months. Whitfield requested an exceptional sentence below the standard range. He admitted that he should not have responded to Lynetta's verbal confrontation by hitting her, and that the degree of force he used was excessive. But he argued to a significant degree Lynetta provoked the incident. Whitfield filed letters and declarations from numerous family members that supported this claim. Whitfield also argued that when they were outside trying to leave, Lynetta first struck him in the face and that he hit her in response and in an effort to restrain her. This is an important point that comes after that. The trial court found that Lynetta began and pursued a controversial, confrontational, and accusatory conversation with Morris, and that by her insistent behavior, Lynetta was a provoker of the incident. The court further found that Lynetta did not strike Whitfield, but her repeated verbal conduct ultimately provoked a violent response from Whitfield, and that Whitfield's response was disproportionate to the provocation. The court concluded that the extent and existence of Lynetta's conduct was sufficient to support an exceptional sentence below the standard range, and imposed a sentence of 6 months partial confinement, conditioned on his immediate enrollment in prearranged inpatient drug treatment. Now, as the parties have cited and the court has also stated, the legislature has determined that certain failed defenses may constitute mitigating factors supporting an exceptional sentence below the standard range. In one such case, State v. Hutzel, the Washington Supreme Court cited to Professor David Berner, which all of the lawyers in the room will be familiar with as a longtime criminal law professor at the University of Washington, and essentially the author of Washington's Sentence Reform Act. That case, citing Professor Berner, says, the guidelines contain a number of mitigating factors applicable in situations where circumstances exist which tend to establish defenses to criminal liability, but fail. In all these situations, if the defense were established, the conduct would be justified or excused, and thus would not constitute a crime at all. The inclusion of these factors as mitigating factors recognizes that there will be situations in which a particular legal defense is not fully established, but where the circumstances that led to the crime, even though falling short of establishing a legal defense, justify distinguishing the conduct from that involved where those circumstances were not present. Allowing variations from the presumptive sentence range where factors exist which distinguish the blameworthiness of a particular defendant's conduct from that normally present in that crime is wholly consistent with the underlying principle. The state of Washington has also argued in the Whitfield case that the application of that statutory mitigating factor should be limited to situations in which the provocation by the victim was more than words. For the same reason, the Washington Supreme Court rejected the state's argument that a sentence below the standard range is warranted under the initiator, aggressor, provoker mitigating factor only where the defendant's response is proportional to the victim's provocation. Reasonable force used in lawfully defending oneself constitutes lawful self-defense and is a complete defense to the charge, and therefore an exceptional sentence would not apply in that case. The only proportionality requirement in the mitigating factor as currently codified is that to a significant degree the victim provoked the incident. This court also reviewed State v. Pascal. In Pascal, the defendant stabbed her boyfriend and was convicted of first-degree manslaughter. The crime carried with it a presumptive sentence of 31 to 41 months. At trial, the testimony reflected that the decedent had previously physically and verbally abused the defendant, and on the day of his death, he had shoved her, slapped her, and knocked her down. After the decedent threatened to leave and take their daughter from the defendant handed him a knife and told him to stab her because without her daughter, she had no reason to live. They continued to argue, and then he gave her the knife, and she testified he threatened to leave her and their daughter, and so she stabbed him. He died. Pascal was charged with second-degree murder and manslaughter. At trial, she contended she acted in self-defense and suffered from battered women syndrome. The jury rejected that and said that she lacked the requisite intent to murder her boyfriend but did not act in self-defense. She was convicted of manslaughter and faced a sentence range of 31 to 41 months. The trial court sentenced her to 90 days incarceration and 240 hours of community service. The Washington Supreme Court affirmed. This court wishes to admonish Mr. Kemp in the strongest possible terms that arming oneself in these circumstances could have resulted in the loss of innocent life, a tragedy which would be irreparable. I cannot state strongly enough that this could have been easily avoided by simply walking away. Property is replaceable, human life is not. This court has reviewed the facts presented by the parties as well as the applicable law. This court has determined that there are substantial and compelling reasons to impose a sentence below the standard range, and therefore, Mr. Kemp is sentenced as follows. Mr. Kemp will be sentenced to 30 days, converted to electronic home monitoring. He will serve 12 months of community custody, and as a condition of that community custody, he must complete 20 hours of community service per month for a total of 240 hours during the coming year. That community service is to be done the majority of the time in the Tacoma-Pierce County area. The reason is it's being imposed for a twofold purpose. First, for Mr. Kemp to engage in positive behavior, which will prevent a reoccurrence of criminal behavior, and second, to restore to the community he endangered by his actions. $500 crime victim penalty assessment, $200 court costs, a requirement of a DNA sample and payment of the DNA fee, no contact with the victims for a period of 10 years, and I believe that covers the sentence. Any questions or clarifications requested?
I just want to make sure that what I write down reflects the court's oral ruling. So my first question is, my understanding is that on an assault 2, that Department of Corrections will screen him, and so I'm just going to predict that they're not going to supervise him.
I think that that's the case, except that they may monitor him for the purpose of completing his community service. If that does not occur, then he will be required to file with this court monthly reports indicating his 20 hours per month of community service.
Okay, so you want something that says something to the effect of, if not monitored by DOC, file monthly reports with the court? Okay.
Yes.
And then the other thing, and I apologize for my ignorance here, I don't
okay.
have cases where EHM applies. So is that just get written down as 30 days EHM?
So it comes under RCW 9.94A.680. Alternatives to total confinement are available for offenders with sentences of 1 year or less.
Okay.
Okay? There's no exemptions other than, I believe, for sex offenses. So I'm having him do this in lieu of 30 days incarceration. And what I'm going to ask defense to do is to have him on EHM within the next 2 weeks or give him a report to jail date.
Okay.
okay?
But it's 30 days of EHM.
Exactly.
Okay, that's
Yes.
what I was trying to
Okay.
make sure of.
Exactly.
I think those are the only questions that I have.
Thank you.
So I think the electronic monitoring statute precludes violent offenses, and so I'm assuming the court is saying, as a part of the exceptional sentence, I'm
Correct.
imposing this.
That's correct.
Okay, thank you. Your Honor, defense will prepare findings of fact and conclusions of law. Is there a date in which the court wishes to have those findings presented by?
How much time do you need?
I can have it by next week.
Why don't we do this? I'm in CDPJ. We can put it on my Friday calendar, but if you just send it to Mr. Howe and he agrees, then send the final version to Ms. Wood electronically, and then I'll just print it out and sign it, and we'll strike the hearing.
Thank you, Your Honor.
Is that okay?
That's absolutely okay. And the other thing, just to make sure, I don't think you said it out loud, we still get to ask for restitution for the lady's car that got shot?
What I heard was that you didn't have the figures now, and you would do it by later order of the court.
Correct.
That's my understanding.
Okay, that's what I want to put in the
Yeah.
JNS.
Yeah, that's fine.
And my client would waive presence at any restitution hearing. I don't anticipate one would be necessary, but.
Okay. And there is a block in the JNS for his initials.
Okay, thank you, Your Honor.
To signal that. Do you want to schedule that restitution hearing now?
I've got a caller or whatever. I don't think, I wasn't too focused on that.
I understand.
I'll-
We have a scheduling order which Ms. Wood can enter if you wish to do so.
Yeah, what I think probably will happen is that she'll submit documents and I'll show them to Mr. Leary and then we may be able to just give you an order.
All right.
But I know that I have 180 days. I'll make sure that either by getting back in touch with the court or by just dealing with the defense, we'll get it covered before the 180's up.
Okay, thank you.
Okay, I'll start handing these up so they can get signed.
0.
And Your Honor, if I may, I'll hand up some of the sentencing documents now while we fill out the judgment and sentences.
That would be fine. No, so it'll just go in the JNS, and he'll get a copy of it, and then he can take it to some, yeah. I think that's pretrial, yeah. Thank you.
Oh, yeah.
I'll go get one.
Okay. I actually don't know how to do that, so that would be super
You don't need
helpful.
But we're gonna need like conditions and things, like if he's allowed out and things like that, right?
I don't think so.
Yeah.
We just have a report.
I fully intend to allow him to work during that period of time or go to medical appointments or the like.
Well, we need an EHM order that states that, so the electronic monitoring company knows what's allowed per the court.
Yeah. Mr. Leary?
That's fine. So I didn't hear the first part. Do you have an order, or is there a standard order, or we can prepare one and?
There is a standard order. We generally use it pre-trial, do we not?
Yeah, can I make a suggestion?
Sure.
I just had this come up in a different context, and what the defense wanted to do in that case, and I think they were people that knew what they were doing, was they contacted the company they were going to use. They worked out an order that he can go here to do this, that, or the other thing, right?
Yeah.
And then brought it to the court. Will that be acceptable?
That's fine.
We can do that by Friday with other findings.
Okay, and again, I'm down in CDPJ, so I'm easy to find.
Okay, so will that work? You guys can figure it out, and then just bring it to me, and we'll get it to the court.
Okay, the deadline will be 2 weeks.
For report.
2 weeks to be on EHM or report to the Pierce County Jail.
Okay.
Okay?
Well, yeah, I think I'll have to walk over to the jail probably. No, not right this minute. Well, does he do it right now? I don't,
We're supposed to do it in court,
That's what I thought.
but we didn't schedule that.
yeah,
I didn't think about that.
Okay,
so.
we can have them come up to your
Just do a
office or
report
something.
or something.
On the report, too. You know, I'm just asking about the DNA collection.
I'll,
So we have to, are we calling them? Okay, see if he has to make an appointment, because I think that's the next alternative. I think we have to make an appointment for him to report down to the sheriff's office.
Okay.
Because they don't do it after 2 o'clock on Fridays.
Okay, that's fine.
If we can get it taken care of this afternoon, we'll try and get it taken care of this afternoon. Thank you.
So we'll get it figured out.
okay, so do you want to kind of look over my shoulder? This is,
2 weeks.
so, within, sorry.
No, you got it.
Below, right? Count one, none of that, none of that, none of that. Prosecutor did not, okay? And then, that's agents. And then I wrote 0 total confinement, 3 days EHM, respond jail within 2 weeks. If not on EHM, disauthorized as a portion of the exceptional sentence. I don't know. I'm just gonna put per DOC.
Do we want to put the 20 hours a month?
Oh, yeah, yeah.
Majority of Tacoma, Pierce County.
20 hours per month. Community service. Predominantly
Sure.
in Pierce County. Tacoma. Okay.
Switching here.
I put forfeit the gun.
Yeah, I'll jump in.
Oh, at the,
Does that look right?
at the sheriff's department? Okay. So should we do it with, on here?
Yeah. I've already said some things that.
Okay, so for DNA collection, we have to set a DNA return date on my docket, which would be next Friday. And then he can go, it's any day next week, right? Mr. Kemp can go any day next week and report down to the first floor where the sheriff's department is. And he'll have a copy of the DNA order and just indicate that the judge has ordered and provide a sample.
Mr. Kemp will bring a copy, is what you're saying, or they have a
Yes,
copy?
we'll give him a copy of the DNA order. He can bring it with him any day next week before Friday,
Okay.
down on the first floor to the Pierce County Sheriff.
Yeah.
It's 2 weeks from today. Is there a counter on there?
We'll show you what.
That week, the 5th.
5th,
2.
September 5, right?
Anything you think I missed? So, this is the appendix. Where was Nate last head coach? Toronto?
Lakers. He's a head assistant. He'll be
Where was he a head coach last?
Atlanta.
Okay. That's close to where we're gonna get something. That was good? Yeah. Okay, all right. No, it's usually on the agenda. I kind of made some of this up as I went along, okay? Okay. Place for the initials for the waiving institution and two signatures, one signature for the JNS and one for the board. Order attached, okay. I think you haven't got to them yet. Okay. But I think there's at least one initial and at least two signatures. There we go. Okay, waves. Yeah. So, signature for waiving.
The initials?
Yep, right there. We'll give you a copy of all this too. Signature right there. Signature right there. All right, so left 4, left thumb. So down. There you go. Thumb. There you go. Same through your right. That's good. Okay. There's that. What's your address?
5432.
Oh, that's mine. Okay. Have you signed right there?
1732.
Okay.
Your Honor, heading forward the judgment and sentence, I believe it accurately reflects the court's oral ruling. I do have the fingerprint page, I'm just getting the address.
Thank you.
I don't know what it is. Schedule in order. Oh, I'm good. I'll pull it up. Okay. Got a second after this, or you got something else you need to do? No, yeah. 100.1 thing.
I'll get a copy of the JNS. I know Adam Faber wants a copy, so.
Good thinking. He's actually been a pretty good addition here, I think.
Adam.
Kind of works out.
Okay, I'm going to hand down the no contact orders to be served on Mr. Kemp in open court.
Copy machine.
It's right there.
Copy machine.
I'll just copy it for you. All of this depending on you.
Might as well.
Mr. Kemp, serve through counsel with copies of the 2 no contact orders.
Acknowledge receipt, Your Honor.
Thank you. The court has reviewed the judgment and sentence and warrant of commitment. They do conform with the court's oral ruling, and therefore I've signed them in open court, then in the presence of the defendant.
Thank you, Your Honor.
Thank you very much.
Anything further on this matter?
May we return to our other duties?
You may. We'll be at recess.
Thank you, Your Honor.
All right.
Woo!